Hi, I'm Mark Nacol, the Nacol Law Firm, and I was requested to chat with you folks on the issues of civil litigation. We have been civil litigators for a long time in this law firm, and we've tried jury trials across the spectrum, and I couldn't possibly, in a short 5-minute discussion, go into detail, but I can give some of the core issues to look at as to determining whether you have a lawsuit or not, whether you even have a reason to speak to a lawyer. Let's start off with breach of fiduciary duties. That is one of the lawsuits that bears fruit and is puts a lot of fear in people who commit fraud, who are people who owe fiduciary duties and intentionally violate them. Any professional that has a special duty to be faithful, it's often described in jury charges as that duty you owe to a brother. Now, you might not do things that you would like to tell everybody about to a stranger that wasn't nice to you, but it's not actual. But your brother is someone that you don't cheat. You take care of your brother. And that goes into buy-sell agreements in corporations. That goes into actions by corporations, limited partnerships, especially general partnerships. The partner owns the highest duty under law to the other partner to act in a fully straightforward, fair, full disclosure, honest way. If he doesn't, he may have to answer in a court of law. It always can give rise to actual damages, and if a breach of fiduciary duty is involved, in a tort or a contract, it can give rise to punitive damages in excess of the actual damages, subject to some laws regarding subjectivity and knowledge in advance. Fraud is another area that we have participated in for our clients who have been defrauded that gives rise to punitive damages or additional damages, and including to the actual damages incurred. Fraud is, simply stated in lay terms, a lie that you know about before you tell it. It must be a priori, which means it must be somebody who gets together to defraud you. If you find out your home that you just purchased for several $100,000 has a broken foundation, and they knew about it, that is probably fraudulent, but it's most certainly a breach of contract. If you find out that the realtor and the seller had a report that the foundation was broken and they didn't even list it on the disclosure statement, that's a laydown. That is fraud, pure and simple, and there's not much of a defense that a jury or a judge is going to listen to. Everybody, even in a contract, has a duty to not lie and cheat the other person. But if somebody just is hateful and mean and lies like hell in a relationship and a contract, that's not fraud. You can't maliciously breach a contract. You can do it, but you can't recover for it. It has to be something planned before, a scheme, a course of conduct that resulted in the deception. We have had a whole large ream of cases over the years that sound in all these different areas. We're old dogs here, and though I'm board certified in civil trial law, we have some backgrounds in real estate, construction, and other areas that we're not board certified in, but we have much experience in those areas. And so if you feel like you've been defrauded, if you're subject to a breach of contract, if you're subject to fraud, or if somebody in a trustee for your trust, an executor of an estate you inherit, has been dishonest, there are very, very high penalties for that, and the courts and the laws of the state of Texas and the common law will protect you. If you feel like you'd like to discuss something that's relative to these issues, please give us a call, Dallas, Texas, 972-690-3333, or go to NacolLawFirm.com. We have many blogs on this issue that you can freely look at, and give us a call. We'd be glad to help you.